For me. Michael, if you're ready to begin, I'll hand it off to you.
Thank you. Hi, everyone. My name is Mike DeBliss. I am an attorney in private practice based in New Jersey, and this is a presentation on offshore audits and the Fifth Amendment active production doctrine. There's a lot of information here, so we're going to go through quite quickly but thoroughly. So what I'd like to do as a way of background is to set the stage. There is this inherent tension between the government and the taxpayer when it comes to information gathering, and that could not be any more apparent than in the case of an offshore audit. In offshore audits, revenue agents are often armed with incomplete and inaccurate information provided by foreign banks. And this information usually comes from FATCA, the Foreign Account Tax Compliance Act. And they realize, the revenue agents, that is, that they have to fill the gaps to make their case. And the way they can gather the information that they need is only through the taxpayer or his accountant. So it's the taxpayer or his accountant that can provide the missing link, so to speak, in order to supply the missing piece of evidence that the government needs to potentially bring a criminal prosecution. And as you can imagine, the taxpayer is not so thrilled about the idea of turning over that information. And what I want to do here is right from the get-go dispel any myths about offshore audits. They can and oftentimes do result in a referral to criminal investigation, CI arm of the IRS. So for better or for worse, the third-party information usually supports the conclusion that the taxpayer violated one or more federal criminal statutes. And again, that's the reason why there's this tension where the taxpayer doesn't want to give up information that is potentially the silver bullet in the government's case against them. And as you can see, I've come up with a number of different metaphors and similes for how to look at this. I've already thrown about a few terms like silver bullet. It's like an old-fashioned Western duel, and this might appeal to some of you, where one cowboy, the taxpayer, gives the other cowboy, an IRS revenue agent, the bullets and ammunition needed to load his empty barrel. So in a very real sense, it's that silver bullet that the government needs to successfully prosecute the taxpayer. If this is an area of law or an area of practice that's new to you, it can be quite confusing because for those who try criminal cases, street crimes cases, discovery is basically worked up by the detectives and independently from law enforcement. But in cases like this, as I've already explained, a lot of the evidence that the government needs to make its case is in the possession of the taxpayer or his or her accountant. And that's what makes this different from your typical run-of-the-mill street crimes case where everything is provided to you by the law enforcement agency, local law enforcement agency. So because of how devastating the information could be to your client's liberty, it goes without question that great care should be taken to assert all applicable privileges, including the Fifth Amendment privilege against self-incrimination. So here are the list of privileges. I've named the main ones, beginning with the Fifth Amendment privilege against self-incrimination, and that can be further divided into the privilege and testimony and the privilege and document production, which is what we're focusing on in this presentation. The second main privilege is immunity. The third is the attorney-client privilege and work product privileges. So we're not going to have time to cover all of the rest, just the one that's highlighted in blue. So as a way of background, tax cases are document-intensive cases. And as previously discussed, if the government can't get the requested documents, it can't make its case. And so it's for this reason that the seminal issue is whether the taxpayer has a Fifth Amendment privilege with respect to the documents that he possesses. Now, we're all familiar with the Fifth Amendment privilege against self-incrimination. Certainly, when we were in law school, our criminal procedure professors beat this into our heads. No person, and this is what it says in the Constitution, shall be compelled in any criminal case to be a witness against himself. Ordinarily, the Fifth Amendment applies to the live testimony of a witness at a judicial proceeding in a criminal trial or to custodial interrogation of a suspect by law enforcement. And the first thing that comes to mind there are the Miranda warnings. But it may also be asserted during a congressional hearing before a House Oversight Committee, such as that involving Mark McGuire during the committee's open hearings on steroid use in Major League Baseball. But live testimony is not all that the Fifth Amendment protects. It also protects something just as sacrosanct, and that's the compelled production of business records in specific situations. And fortunately, there is a trio of cases that flesh out this concept. The Fifth Amendment privilege is really straightforward in cases involving testimony, but when it comes to cases involving document production, it does become very confusing and and requires a lot of detail. So what we're going to do here is, almost split hairs and peel the layers of this, down to its bare bones so that it's understandable. So during the government's information gathering stage, which roughly coincides with the stage in which they've gathered information through FATCA from foreign banks about certain taxpayers. Some of you might be familiar with the different treaties that exist under FATCA. One is a Model 1 treaty, the second is a Model 2 treaty. But suffice to say, all this means is that the government is acquiring information about taxpayers, U.S. taxpayers, who have foreign bank accounts offshore. This information is coming in by droves. Some of it comes in aggregate forms, meaning that it's miscellaneous and the banks are merely disclosing how many U.S. clients they have and how many of those U.S. clients maintain various types of accounts with them. Other information is shared that is shared is more specific, where it specifically names the taxpayer. And this is all new because before FATCA, the way that the government obtained information from foreign bank accounts about U.S. taxpayers is by issuing a John Doe summons. But now with FATCA, information has become so much more accessible to the U.S. government. And if it's a Model 2 treaty that's in place between the U.S. government and a foreign jurisdiction, then the information sharing essentially occurs between the IRS and the foreign bank itself. And the foreign bank is required to turn over what is called nameless aggregates, or information specific to the number of U.S. Individuals who maintain foreign accounts at the institution and the types of accounts that they maintain. They're not required to specify the names of the individual account holders. But the IRS, through a second course of action, has the power to actually uncover the names through a Model 2 treaty. In a Model 1 treaty, the IRS basically sidesteps that intermediary step of having to get the nameless aggregates and goes right to the source. So the information sharing occurs directly between the IRS and the foreign jurisdiction, or the foreign jurisdiction's taxing authority. And the foreign jurisdiction's taxing authority is required to turn over all information specific to the number of U.S. account holders, their names, and the type of accounts that they maintain at various institutions within their jurisdiction. And so those are the two different models that exist. But nonetheless, the information that's shared, whether it be through a Model 1 or through a Model 2 that has the specificity of the names of the individual tax holders or individual U.S. tax holders, this information is not ordinarily enough for the government to initiate its investigation or really get deep into the investigation to determine whether there has been noncompliance. So this is where the Fifth Amendment concerns arise when the taxpayer is asked by the IRS to produce records or other documents. And so here's a question that oftentimes comes up. Who bears the burden of proving that the privilege exists? And the circumstances here are one where the IRS issues perhaps a summons to the taxpayer requesting certain information, and the taxpayer resists it or is looking to or is refusing to turn over the information. Who has the burden of proving that the Fifth Amendment privilege exists in that case? And as should be obvious, it's the taxpayer. The taxpayer must make at least a prima facie showing that responding to the information request would criminally implicate him either in this crime or another crime. And as you can imagine, that is a very high hurdle to overcome. So here, federal jurisprudence attempts to balance two things. First, the desire to protect individual citizens from excessive governmental intrusion against the government's need to properly enforce the laws by using evidence independently obtained through skillful investigation. Number two usually swallows up number one. So in order for the privilege to apply, statements must be compelled at the time they are made. This is something that shouldn't come as a surprise. This is part of the Fifth Amendment definition that we're introduced to in criminal procedure. It's the compelled production of information. So as is logical here, a witness who voluntarily testifies or willingly produces documents in response to a summons or subpoena can't later fall back on the claim that they were privileged because they voluntarily turned it over. And so what we get from that is the United States Supreme Court weighing in on this idea that the act of producing documents in response to a subpoena may be subject to the Fifth Amendment privilege against self-incrimination. That word may cannot be emphasized enough because, as we will come to see here, Fisher has a lot of specificity in it, and we're going to delve into the facts of the case. So in the case, the government issued summonses for the records of two taxpayers which were created by the taxpayer's accountant but later transferred to and held by attorneys for tax preparation purposes. The holding in the case is that the enforcement of the summonses did not violate the Fifth Amendment privilege. However, in a unanimous opinion, the court refused to cut the Fifth Amendment completely loose from the moorings of its language and make it serve as a general protector of privacy. The decision left the door open for future Fifth Amendment cases as they apply to tax. And so here are the major takeaways from Fisher. And this is what again ushers in this this field of cases that addresses the Fifth Amendment and document production. First, even if the documents themselves aren't privileged, the act of producing them in response to a subpoena nevertheless has communicative aspects of its own, wholly independent of the contents of the papers produced. So what the court is acknowledging here is that the act of actually turning something over in response to a subpoena has communicative aspects of its own that could insinuate or infer criminal conduct. And that's wholly independent of what the actual documents contain, meaning the substance of the documents. Just the act of turning it over could be incriminating. Second, and if this testimony and admission that the requested documents exist is critical to the prosecutor's case and not merely a foregone conclusion that adds little or nothing to the sum total of the government's information, the privilege may attach. Third, if the existence and location of the papers are a foregone conclusion, then the taxpayer adds little or nothing to the sum total of the government's information by conceding that he has the papers, then the act of production privilege does not apply. That's, no harm, no foul. If the existence and location of them are a mere foregone conclusion, and the taxpayer turning them over basically adds nothing to the sum total of the government's information gathering, then the act of production privilege does not apply. Here we enter the second of what are the three main United States Supreme Court cases on document production. And this is the case of United States versus Hubbell. This is the infamous Whitewater case. Some of you, I am sure, are very familiar with this. It's dating back to 1996, but it did receive a lot of media attention. This was the case where independent prosecutor Kenneth Starr served as subpoena duce tecum on former Arkansas lawyer Webb Hubbell. And in that subpoena, he ordered Hubbell to bring documents before a Little Rock grand jury. Webb subsequently refused to testify about the documents or even acknowledge whether or not they existed, relying on his Fifth Amendment rights. The district court threw out the subpoena as a quintessential fishing expedition, but an appeals court later reinstated it. What was the argument that the defendant made here? It was that the only way that the government was able to bring this prosecution was through the information that he produced. And the holding was that the indictment should be dismissed. The Supreme Court held that where a document communicates information about the document's existence, custody, and authenticity, the mere act of production is incriminatory, and the Fifth Amendment privilege applies. That phrase right there is a linchpin. It's something that you want to write down and keep next to you at all times, because these three elements, the communication information, that the document communicates information about existence, custody, and authenticity. This is the trio that comes up a lot in these document production cases. So in a near unanimous opinion, Justice Stevens essentially extended Fisher. Once again, he focused on the production aspect as analogous to testimony, likening it to a prisoner forced to try on a shirt in order to link him with a prior criminal act. The compelled testimony, the court said, that's relevant in this case is not found in the contents of the documents produced. It is rather the testimony inherent in the act of producing these documents. Unlike Fisher, the court contrasted this by saying that Prosecutor Starr would have had absolutely no case against Hubbell unless he had access to the withheld documents. This is what the court said. In sum, we have no doubt that the constitutional privilege against self-incrimination protects the target of a grand jury investigation from being compelled to answer questions designed to elicit information about the existence of sources of potentially incriminating evidence. And if I had a highlighter here, the part that you really want to, that I would really emphasize, is the latter part that says, answer questions designed to elicit information about the existence of sources. So the information that Hubbell was being requested to disclose, by the mere production of that information, it would have revealed the existence of sources that would have been potentially incriminating. And this is the court's reasoning. It's a very lengthy opinion, and I'm sorry to beat it to death, but it's such a critical case in the document production field that it really deserves this much attention. The information is so voluminous that the prosecutor needed the defendant's assistance both to identify potential sources of information and to produce those sources. Given the breadth of categories of documents called for by the subpoena, the collection and production of the materials demanded was tantamount to answering a series of detailed interrogatories or a series of deposition questions. Providing a catalog of existing documents fitting within any one of 11 broadly worded categories could surely provide a prosecutor with leads to incriminating evidence. And so, reducing this case to its bare bones, what does the act of producing documents concede? First, the existence of documents demanded. Second, their possession or control by taxpayer. And third, the taxpayer's belief that the documents produced are those described in the subpoena. And that's a fact that the government can use to authenticate them. So these are the three main takeaways from the Hubble case. And the three main things that you should look for whenever your client is thinking about raising the Fifth Amendment in document production as a defense to a subpoena. We have from U.S. versus Couch this notion that the privilege applies only to compelled testimony, voluntarily prepared documents, just like voluntary statements aren't privileged because no compulsion is present. And the quick and dirty example here is that a taxpayer who voluntarily produces documents in response to a summons or subpoena cannot later claim the privilege. Fisher stands for so many different things, and this is a subtle thing that came up in the Fisher case, but that is definitely deserving of some attention. And that is that the privilege only protects a person against being incriminated by his own compelled testimonial communications. Documents prepared by individuals other than the taxpayer are not protected. If you remember from the brief recitation of facts that I gave on Fisher a little while ago, that the tax records weren't in the taxpayer's possession. They actually started in the taxpayer's accountant's possession and were later transferred to and held by the attorneys for tax preparation. So this whole idea of the information being compelled from the actual taxpayer himself is tantamount in Fisher because the records were actually being held in the custody of the attorney. That's where their eventual resting spot was. So the question that's posed here by the court is, are the tax records of a taxpayer created by the taxpayer's accountant but later transferred to and held by the taxpayer's attorney for tax preparation subject to the Fifth Amendment? And the court held that the taxpayer's tax records, which were obtained through a summons on the taxpayer's attorney, are not protected by the Fifth Amendment privilege in privilege against self-incrimination. The court reasoned that they were the accountant's own work papers. And here was the analysis. The summons and the order of the court enforcing it were directed against the accountant, not the taxpayer. The accountant's work papers are not the taxpayer's. They weren't prepared by the taxpayer, nor did they contain any testimonial declarations by him. Therefore, the ingredient of personal compulsion against an accused is lacking. So you can see here that this Fisher opinion was huge. I mean, it definitely sent shockwaves through the tax community on this pivotal issue because it addressed so many sub-issues relating to document production. And here becomes, the logical question. Well, what if the tax records weren't in the attorney's possession but were still in the taxpayer's possession? Would that alter the result? No. And that comes straight from the Fisher court. However, the court acknowledged two important things. First, that a subpoena served on a taxpayer requiring the taxpayer to produce an accountant's work papers that are in his possession involves substantial compulsion. And second, that the contents of the accountant's work papers might very well be incriminating. But, and here's the big but that the court said, the act of producing the work papers is all that the taxpayer is being compelled to do. It doesn't compel oral testimony. In other words, it doesn't compel the taxpayer to restate, repeat, or affirm the truth of the contents of the documents sought. And so what this issue in Fisher stands for is that the privilege against self-incrimination protects only the act of producing subpoenaed evidence and not the tacit averments within the documents themselves. What if the taxpayer is a corporation? Some of you may have that issue right now lingering where the client is actually the corporation. And just to back up a little bit, due diligence will always necessitate identifying who your client is. And while that might sound very basic and rudimentary, when it comes to representing shareholders or members of a board or a corporation, this is the first question that has to be asked and answered. And it has resulted in a spawn of litigation, that many of you, I'm sure, are very familiar with. So when the question becomes one of who is the taxpayer and who is the client, you always want to backpedal a little bit and answer that fundamental question. But what if the taxpayer, we're going to assume now, is a corporation? Does the privilege apply if the corporation receives a summons or subpoena for records? And here the answer is no. There is what's called the collective entity doctrine. Corporations and entities have no Fifth Amendment privilege. Only the individual who responds on behalf of the corporation, for example, the custodian of records, can potentially assert the privilege. So when objecting to a summons or subpoena on Fifth Amendment grounds, it has to be asserted at the right time. And the reason for that is that, number one, there are legal questions, and number two, ethical questions. And with respect to the ethical aspect of this, it's a matter of professional responsibility. Defense counsel can't advise his or her client to disregard a summons unless there is at least a good faith basis to challenge it. If no such basis exists, defense counsel can't instruct his client to ignore it just for the sake of obstructing the investigation. I mean, that, of course, would be, grounds for an ethical violation and potential criminal repercussions that could stem from that. So as bad as the client might be looking for reassurance that he has a valid defense under the Fifth Amendment, you as a tax professional or attorney have to look at it from the legal perspective and provide practical and sound advice. And if it's nothing more than an exercise in futility, then you don't want to endorse it or in any way suggest to the client that there is something there when there isn't. If there's a good faith basis, and that's really what the standard is, a good faith basis to challenge the summons, when should the privilege be asserted? Here's two choices. First, at the earliest stage possible so that it's preserved. Second, at a contempt proceeding after the taxpayer defies a court order enforcing compliance of the summons and the court is considering imposing sanctions. Well, it would be foolish to wait until a contempt proceeding. In fact, that would be borderline malpractice. You want to assert the claim at the earliest stage possible, assuming, of course, that there's a good faith basis to challenge the summons, and that would be during the summons enforcement process. Now, the prosecutor has the ability to confer active production immunity. Well, what does that mean? And so let's back up a little bit and let's set the stage. The government really wants the stuff, but under Fisher, the very act of turning it over is incriminating. The government could theoretically grant the taxpayer immunity with respect to the act of production. And what does that mean? Well, the government, if they offered active production immunity to your client, wouldn't be able to use the fact that he turned the documents over in response to a subpoena or a summons to authenticate the documents. So let's back up even further. Whenever the government in a criminal case is seeking to introduce documents, there has to be some form of authentication. They can't randomly and arbitrarily introduce evidence without authenticating it. And the same holds true when the information was the same, especially, I should say, holds true when the information that they are seeking to introduce into evidence comes from the defendant, him or herself. What the active production immunity does to